Welcome to this tutorial video. This video introduces the domain Self-Determination of the Indigenous Navigators Climate Change module. The issues covered in this domain relate to the general framework for the protection and promotion of Indigenous peoples' human rights. It includes the right to self-determination, the right to free, prior and informed consent, and the right to non-discrimination, both as a collective and an individual. States have legal human rights obligations to uphold these rights in all policies, including climate change-related laws and policies. The preamble of the Paris Agreement acknowledges the importance of respecting human rights and the rights of Indigenous peoples in the context of climate action. It calls for parties to consider these obligations when taking action to address climate change. Recognition of these rights are also critical for protecting the collective and individual rights that Indigenous peoples have to land, territories, and resources when implementing climate change-related measures, and ensuring that Indigenous peoples and their representative institutions are meaningfully engaged in decision-making processes on climate change-related measures. The first issue looked at is self-determination. Indigenous self-determination refers to the right of Indigenous peoples to freely determine and control their livelihoods, destiny, culture, and customs. The right is recognised in the UN Declaration on the Rights of Indigenous Peoples, or UNDRIP, in Article 3. It is also established in legally binding international agreements, such as the International Covenant on Civil and Political Rights in Article 1, the International Covenant on Economic, Social and Cultural Rights in Article 1, and in the preamble of the International Labour Organization's Convention 169, or the Indigenous and Tribal Peoples Convention. Questions in this category assess whether Indigenous peoples are recognised as distinct groups in national legislation, for example in the National Constitution, and whether this recognition also extends to climate change-related laws and policies, such as nationally determined contributions, or NDCs. The next issue is consultation and free, prior and informed consent. A fundamental component of the right to self-determination for Indigenous peoples is the right to free, prior and informed consent. Under this category, the focus is on the obligation of states to consult with Indigenous peoples in order to obtain their free, prior and informed consent on climate change-related administrative and legislative measures affecting them, and with regard to any climate change-related projects affecting their lands, territories, or resources. States have obligations to consult Indigenous peoples before adopting and implementing climate change-related administrative or legislative measures that affect them. States must also consult and cooperate in good faith with the Indigenous peoples concerned in order to obtain their free, prior and informed consent prior to the approval of any project affecting their lands or territories and other resources. This is set out in Articles 19 and 32.2 of UNDRIP. This includes climate change-related projects. ILO Convention No. 169, Articles 6 and 7 also say that states need to consult Indigenous peoples with the objective of reaching agreement or consent regarding a proposed measure. The National Survey assesses whether the state recognises its duty to consult Indigenous peoples before undertaking climate change-related measures that affect them, and whether there are procedures or measures in place that ensure this appropriate consultation, such as environmental impact assessments. The Community Survey assesses the quality of consultation processes, specifically in the context of climate change-related measures. This involves considering how inclusive they were and whether they met the requirements of the standard of free, prior and informed consent. The National Survey includes an additional category of questions which are on non-discrimination. This category investigates the obligations of the state to ensure the full enjoyment of rights and fundamental freedoms for Indigenous peoples without discrimination that is vital to their self-determination. Questions in this category assess the ratification status of the relevant international and regional instruments which provide the required protection of Indigenous peoples' rights, also in the context of climate change. Whether any recommendations from human rights mechanisms related to the impacts of climate change and climate change-related measures on Indigenous peoples have been issued, and whether they have been implemented. And if states have taken steps and have adopted legislative measures to protect Indigenous peoples' rights. International instruments on the rights of Indigenous people, like the UNDRIP and ILO No. 169, outline that states should conduct social, spiritual, cultural, and environmental impact studies prior to any planned development activities that may affect Indigenous peoples. The Committee on Economic, Social, and Cultural Rights in General Comment 24 specifies that the state obligation to protect entails a positive duty to adopt a legal framework requiring business entities to exercise human rights due diligence in order to identify, prevent, and mitigate the risks of violations of covenant rights, to avoid such rights being abused, and to account for the negative impacts caused or contributed to by their decisions and operations and those of entities they control on the enjoyment of covenant rights. Impact assessments must be conducted in cooperation with Indigenous peoples' representatives and are an important component of consultation with the goal of obtaining free, prior, and informed consent. The full enjoyment of individual and collective rights is critical to ensuring non-discrimination. UNDRIP says that states must take measures to ensure continuing improvement of Indigenous peoples' economic and social conditions. The International Covenant on Economic, Social, and Cultural Rights, or ICESCA, provides standards for how rights realization should be resourced as part of the progressive realization of these rights. Article 2 of ICESCA says that states need to allocate the maximum of available resources for the fulfillment of economic, social, and cultural rights. Available resources also includes funding from international assistance. This places an obligation on states to act in good faith and provide or request international assistance based on their capacity or need to assist with resourcing rights fulfillment. In the context of climate change, this has been expanded upon in other standards. The UN Framework Convention on Climate Change, or UNFCCC, says that due to the global nature of climate change, there is a requirement for the widest possible cooperation by all countries to create an effective international response. However, it recognizes the link between industrialization and climate change, and that there are some countries that historically and currently contribute more to global greenhouse gas emissions. The principle of common but differentiated responsibilities used in the UNFCCC means that while all countries have a shared obligation to address climate change, they do not have equal responsibility to address global environmental issues. The UNFCCC uses the terms developed and developing countries to refer to these differences in contributions and responsibilities. Using the terms developed or developing countries based on industrial or economic status is no longer widely supported. However, the obligations set out by the UNFCCC based on these distinctions remain the leading internationally agreed upon obligations for resourcing climate change mitigation and adaptation. Article 4.3 of the UNFCCC calls on developed countries and other developed parties to provide new and additional financial resources for climate adaptation and mitigation. The parties that fall into this category are listed in Annex 2 to the Convention. This means that in this category of the surveys, some questions are targeted at so-called developed or developing country contexts. It will say which at the start of the question. Answer the questions that are relevant to your context and skip questions that are not relevant. If you're unsure, you can check the list of developed countries recorded by the UNFCCC in Annex 2. You can find this on the UNFCCC website.